Voters have some control over who becomes a prosecutor and a judge, but once in office, most stay there in good graces of the public unless a major scandal or energetic competitor appears. Let's take a look at responding to misconduct in the courts. A range of potential responses to prosecutorial misconduct have been offered or implemented. Many of these have weaknesses that prevent their effectiveness. To enforce rules of ethics, the American Bar Association, or the ABA, has a standing committee on ethical responsibility to offer formal and informal options or opinions when charges of impropriety have been made. Disciplinary committees investigate a practicing attorney only when a complaint is lodged against him or her. One of the most common complaints against attorneys is that they allow deadlines to pass or miss court dates. It seems that prosecutors may be even less likely to be the target of bar discipline committees than criminal defense attorneys. Misconduct in the courtroom is sometimes orally sanctioned by trial judges, but prosecutors are rarely directly mentioned in appellate holdings even when the case decisions are overturned. Some have argued that the evidence of prosecutorial misconduct supports rethinking prosecutorial immunity and perhaps employing criminal sanctions against prosecutors. There is some argument that prosecutors do not get sufficient training on Brady obligations that then lead some of the Brady violations that appear in wrongful convictions. Prosecutors' associations advocate enhanced training on Brady obligations to reduce violations. While the number of Innocent Project affiliates is growing and groups have been successful in identifying cases and prevailing in court, they can't be the only solution to the problem of false convictions. DNA has been the vehicle by which many innocent prisoners have obtained their release from prison. Because of the pro-prosecution bias that is said to exist in state or local police crime labs, there have been calls for private labs to test evidence. Procedures can also ensure that obtaining confession occurs in a manner designed to minimize the potential for false convictions. There is new attention to and interest in addressing the weaknesses of the justice system to reduce the number of wrongfully convicted people. The way to reduce misconduct includes 5 approaches. First, instituting an open file pretrial discovery. Second, abandoning the harmless error test. Third, identifying errant prosecutors by name. Fourth, stripping prosecutors of full immunity. And fifth, investigations of misconduct by prosecutors. Ethical misconduct by prosecutors is expensive and threatens the very legitimacy of our legal system. Just because there's an allegation in an appeal that prosecutors engaged in misconduct does not make it so. Individuals on the side of defending the wrongfully convicted may be subject to confirmation bias as well and have their own ethical blinders on.